Hi, hello. Welcome to Lawyers Infohub. It's always a pleasure to be on your faces on this platform. My name is Mercy. I'm the host on Lawyers Infohub. I appreciate my returning subscribers for always stopping back to check what is new on the channel. And for you, please watching me for the first time, I really appreciate you. And I hold it dear to my heart. I appreciate you. Thank you for stopping by to check what is new on the channel. And for you who will watch later, thank you for watching. Please do consider subscribing to the channel. We have several videos on the channel that are very insightful. They are very um, educative, that will help you in your career. Are you a law student? We have various videos for you that will help you in your academic excellence in becoming the best you can ever be. So today we're looking at defenses to defamation. We try to demystify, simplify legal concepts in the most easy way for ease of understanding. So we're looking at defenses to defamation. Go through our channel. We've done videos on defamation, issue of libel. So today we're looking at the defenses in a holistic way. So what are those defenses a defendant can put up when sued for defamation? The first of them is what we call the justification or truth. What does this mean? This means that the words or the statement that is being considered defamatory is true or substantive or substantially true. Sometimes somebody can make such a statement in self-defense. For example, when two people are insulting themselves, they are insulting themselves at the heat of the moment, at the peak of that insult. Someone chose, says something to another to retaliate the insult in similar words. Then this is where you can now say, well, there's a justification for what I said, or there is truth of what I said. This thing I said is true. So if the defendant can have a defense to say that I'm justified in what I said or what I probably, because it was at the peak of insulting each other that those words came out, or I said those things, or I wrote those things, or these things I said are true. So it's very, 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 very important. Another defense is what we call the innocent dissemination. When someone have written something that is considered defamatory, and another person shares it, they're also guilty of the crime. They're also guilty, yes, of that offense. So innocent dissemination, where you innocently shared, where you innocently posted, and you can show that it was innocently. If you can prove that, it can also serve as what? A defense. With respect to innocent dissemination, is where you distribute an article such as like a book, a film that contains a defamation without you knowing of that defamatory content. You didn't know this thing, you just shared it, you didn't even read it, you just shared it, so you didn't know that this was contained in a book, or it was libelous. And your lack of knowledge of the fact that those books, things you shared, contain libelous or defamatory words was not due to your negligence. So you have to, these two issues, these two elements must be there under your innocent dissemination. You didn't know that that publication contained things that were defamatory, and the fact that your lack of knowledge of the fact that this contained libelous or defamatory words or statements was not due to your lack of what negligence on your own part. So another defense to defamation is what we call the offer of amends, where amends have been made by the defendant or the person who is guilty have made amends, you know, like this is unintentional defamation. Okay, I'm offering to make amends. I'm going back to say this is not true. I have done a post to say I apologize. This came out wrongly. I was not well informed. Then it can also be a defense. Now we also have what we call the defense of fair comment on a matter of public interest. The defense of what? Defense of what? Fair comment. A fair comment is a comment or opinion on a matter or issue of public interest based on facts truly stated and comments that were honestly made. So when we talk about fair comment as a defense in defamation, you're talking about a comment. You're talking about when someone made an opinion on a matter or an issue of public interest based on facts that are truly stated, and that comment was made honestly. So the malice on the part of the defendant will, however, the way you can be sure that, see, you made this comment based on malice. You had malice. for the plaintiff. That was why you made this comment. It will fit this defense. But where the defendant can prove that this comment I made was not born out of malice for the plaintiff, then the defense can stand. But once there's an attribute of malice, it has destroyed that plea of fair comment, and it can aggravate what damages that may be awarded in favor of the plaintiff. Now, there's another defense, what we call the privilege, where you make privilege statement. Now, this privilege is of two kinds. You have the absolute privilege and the qualified privilege. So when someone is trying to bring up the defense of a privilege as a defense in defamation, there are things you must understand. Under absolute privilege, there is absolute privilege in a case where the right of action does not lie at all because of the absolute immunity to legal liability. For example, where you have people in the Senate, people in the House of Assembly, because they are doing their work, the legislative work, they are public officers. In the course of their official or privileged communication, they then made statements in the maybe statement that was made with respect to cases that are being handled in court, or issues of judges, lawyers, witnesses. They can come under absolute privilege, that this came out or this was made in carrying out my official duty as a public officer. So, it can fly. We now have what we call the qualified privilege. There's qualified privilege where the law protects a defendant only when a mutual duty to give and receive information exists. Where you're in a position where you give out information and you receive information, so there can be a qualified privilege for that defendant when that comment is what made honestly, reasonably, without malice. You can understand now, see that malice, if proved, defeats your defense. So if they can prove that, see, I didn't have any issue with you, I have no malice against you, I just, it was a comment made freely, honestly, reasonably, without malice, it can fly. Now we have another defense we call consent by the plaintiff. If the plaintiff consented to the dissemination of this information, you can't come back to say you were defamed. Where you have been invited to maybe a press to report events or for an interview, and when the publication now goes beyond the limit of the consent, an action may lie. Just like in the era of social media, where we have people going for podcasts. When you go for podcasts and say certain things, you have to also understand the liabilities you have for you who is saying it and for the person to whom it is said against. So this is very important. When you are being invited to speak in a public or in an interview, you have to mind what you say and be sure of what you say, so that you don't end up defaming people, and that sometimes the dissemination of these videos or interviews may go beyond reach of the person who even disseminated it. So you have to watch it out. So when the plaintiff consents, when you consent, you submit yourself to a podcast and certain things have been said against you. You can't come and say, I was defamed, they tricked me. You have to be very careful in this era of podcasts. In this era of a lot of people going to grant interviews, you have to be very careful, very, very careful. So the defendant can come up and say, you consented to come into the interview, so why are you saying I defamed you? Why are you saying that? So it's very, very important to understand these defenses. Now, when there is death of the plaintiff or the defendant, when there's an action for defamation, it cannot be brought against a dead person. So if for a person you are saying defamed you has died, then the action dies. So reputation is what we call is a personal possession, and only the owner of a reputation can sue in respect of it. So if the person against whom the person that was defamed is dead, then you can't come and say my father was defamed and all of that, because reputation is a personal possession. Reputation is a personal possession, and only the owner of the reputation can sue in respect of it. It's very important. Defamation is an action, is a personal action. So the death of a defendant also brings the action to an end, unless there are other defendants in terms of other people who also felt defamed by that action. What we call res judicata stands as a word, as a defense. So res judicata is all about an estoppel, or where a stopping of the plaintiff for filing fresh suit because one has earlier been filed or has been contested or won or lost. So when someone has filed a suit with respect to a particular defamation, the court, that's what it's on the principle of res judicata. You cannot go back, another person cannot go back and also sue again over that same issue. So the court looks at it, has this issue been determined by the court? Has it been lost, won? Has it been in court? So the court does not allow for multiple defamatory suits when maybe one should cover the rest. So that's what we call the accord and satisfaction. Accord and satisfaction as a defense to defamation. This is what we call the settlement, in which the plaintiff settlement, when the defendant has settled with the plaintiff and there is fulfillment of such terms as settlement. In an example where someone was defamed and the defendant accept, I have defamed you, and the person say, to restitute, you have to publish on your social media page or one newspaper to say what I said was wrong, and the person goes to say it, then it starts as a defense. When maybe the person goes back to system, my Lord, this person said I should, when we got to talk, he said I should go back to my page where I published that false information, or I should go back to a newspaper to apologize. I have done that. So the court looks at it that this is what we call accord and satisfaction. This person has satisfied you to the extent to which you want. So why bring a suit again against the person? So it can stand as a defense to defamation. We have what we call the statute of limitation, the statute bar. A claim for defamation must be filed within the time allowed by the statute after publication, unless it becomes statute bar and it can no longer be brought within the time, within any other time. So there is timing. So if you can't say someone defamed you 20 years ago and you're coming now to sue, so that is what we call the statute of limitation. It can work against you as a defense to the defendant who says, "My Lord, this what happened 30 years ago. Statute of limitation has caught up with it." So, friends, I just hope that you'll be able to learn something, just as an addition to what we are learning today. We're learning what defenses to defamation. We also have done remedies for defamation. What are the remedies for a plaintiff who feels I have been defamed? You can get damages in terms of money compensation. Injunctions can be granted to you. Maybe sometimes injunction, when someone has written a book where you say I've been defamed, injunction can be gotten to stop the sale or the distribution of that book. You can also have interim injunction, perpetual injunction, interlocutory injunction. You have the different types of injunction. People can also offer you apology. These are also remedies for defamation. Apology, when we talked about accord and satisfaction, publication in a newspaper for retracting maybe an embarrassing story or correction of a story. So these are remedies that you can get for defamation. So don't be caught in the web of defamation. Be careful what you say and what you say and what you publish. Remember that defamation is what a personal action, and that it's all about reputation. And reputation is a personal possession, and only the owner of the reputation can sue in respect of it. Please go to our channel. We have wonderful content, over 300 contents for you. We have carefully made for your growth. We are interested in the growth of legal education in Nigeria, in Africa, and beyond. We're interested in your personal growth. We want you to become that excellent lawyer, that excellent law student that you have always desired to be. Do take care and know that you can drop your questions under the comment section and we will attend to it. Thank you and do stay blessed.